Scottish and Northern Ireland differences and issues in a few minutes. Scotland and Northern Ireland have separate legal systems, and the Scottish jurisdiction is substantially different because the country kept its own system after constitutional union in 1707. Most restrictions on the media are similar, for example, the protection of children and sexual offence complainants, the protection of trial by jury through media contempt law and libel. Things to watch out for. If you're a broadcaster or publisher and distribute the same edition between England and Wales throughout Scotland and Northern Ireland, you need to be careful and conscious that media contempt law in Scotland has been traditionally much more severely applied. Publication of the photographs of accused people, unless they are well-known public figures and celebrities, is usually contempt in Scotland until the issue of formal doc identification is resolved during the trial proper. Anonymity for youths in criminal courts in Scotland is now 17 and under, and the same as in England and Wales. In civil and family proceedings, the same anonymity relating to people under 18 that applies in England also applies in Scotland. Injunctions granted in the London courts do not apply in Scotland. A separate process to obtain what is known as interdiction is required. It is a criminal offence in Northern Ireland to publish anything leading to the identification of anyone on a jury or jury panel. In Northern Ireland, courts are more willing to grant anonymity to criminal defendants if there's a risk to life through sectarian vigilante attacks. The reforming 2013 Defamation Act applying in England and Wales at present does not apply in Northern Ireland. Reforming legislation in 2021 made the libel laws in Scotland very similar to those set out for England in the 2013 Defamation Act, such as the public interest defence, the one publication rule, serious harm needed, and a limit of 1 year to sue after publication.